Great. So as Colleen mentioned, this is on advanced care planning and legal decision-making documents. I am not a lawyer, nor am I giving legal advice in this setting. I have, however, worked with a couple of lawyers to be able to kind of put this presentation together and to understand and work with them on their end how these decision-making tools kind of can be played out in the court system and some of the concerns and ways that we can write them so that we can try and mitigate some of the concerns on that, as well as try and help make things clear around what people's goals and wishes are when they're making these documents. So we'll get started. When we think about it, how many decisions do we make every single day? Everything from what clothes we're going to wear, what foods we're going to eat, where we're going to go, what we're going to do with our time during the day. There's a million decisions to be made every single day. And what happens if we no longer have our own ability to be able to make those decisions? That is where advanced care planning comes into play. So sometimes people ask around, why have legal documents in place? It's really important that everyone have legal documents made up who's over the age of 18 in case of an accident or illness. It really is able to outline who has the authority to be able to make those decisions for you. And in Alberta, the law is that another person doesn't have the automatic right to make decisions for you, even if they're your spouse or an adult child or another relative. There has to be a document in place that allows them to legally make decisions on your behalf. And so by creating our own documents, it makes the process a lot smoother, a lot quicker. And we'll go into some of the challenges if we don't have those and what other routes might exist if we don't create these documents. But generally speaking, it's really important that everybody think about and create these documents when they have time. So again, we often think that older people are the ones who really need to have these documents in place, but really it is anyone over the age of 18. Once we turn 18, we have our own legal decision-making abilities. And so what happens if you are in a car accident on the day after your 18th birthday, or there's an injury or an illness that affects your ability to make a decision? It's important that we have these noted, who we want making those decisions for us. And so, as I mentioned, when I was working with a lawyer to be able to create this presentation, he said on his 18th or on his children's 18th birthday, before they let them out of the house as part of breakfast, they sat them down and they gave them the kits and said, okay, you need to create these documents, because he understood how important this was and really what an impact it can have in a person's life should something happen and they not have these documents in place. So I think it's a lesson that we can all take and hopefully implement into our lives. So again, some of the reasons that we want to create these documents would be just insurance for the future. So just a peace of mind of knowing that if something should happen, you've already got these documents drawn up. There's some direction around how you want your family or your healthcare team to be able to proceed, what decisions you want them making, and what your interests are, as well as it gives the individual a voice and a presence, so that even though you might not be able to speak on your own behalf, you've been able to outline and give voice to what you want to have happen in these documents. As well, it really minimizes the time that it takes to go through court processes, and there isn't the same cost involved in this. So it is minimal in cost as well. When we talk about legal documents, we're just going to go through what some of these ones that we're going to cover today are. So the type of decision-making document, medical care. If you make it on your own, we call that a goals of care, or sometimes it's referred to as a green sleeve. If you don't make any decisions or make any note of what you want to happen around your medical care, the doctors and the healthcare team will do all that they can to be able to sustain your life and prolong your life within reason. For personal decision making, and this includes anything that's of personal nature, so whom you live with, what vocation you do, what training you take, legal matters, healthcare matters, anything that's to do with personal decision making. If you make that document, it's called a personal directive. It used to be referred to as a living will, but we no longer use that term. In Alberta here, we call it a personal directive. If for some reason you weren't to have created this document and you need someone to make decisions in your personal matters, that would be going forward with guardianship, which can either be public or private. It's private if someone in your life, a family member, friend, someone you know, applies to the courts for guardianship, or if there's no one to apply and you do require a decision maker, then it's a public guardian who's appointed through the government. For financial decisions, when you make your own document, it's called a power of attorney or an enduring power of attorney, and we'll go into what the differences on those are. If you don't create that document, then it goes to trusteeship, again, either public or private. And for the power of attorney and trusteeship, it is only around financial decisions. There is no personal decisions included in that. And then finally, for your estate decisions, if you pass away and you have created your own document, that is a will. And if you have not created it, it will go to intestate and be handled through the court system. So when we talk about personal directives, the person creating the document is called the maker, and the person that you're giving the authority to is called the agent. For the power of attorney, it's the donor who's creating the document, and it's the attorney who has the legal authority. So you might hear some of those terms, and so I just wanted to make sure that you are aware of how those kind of fit in there. There are two types of power of attorney. One is kind of called an ordinary or a regular power of attorney, and the other is called an enduring power of attorney. So an ordinary power of attorney allows a person who is competent to be able to create the document and give authority to their attorney to make decisions on their behalf from a specific date, and then it can be revoked. So usually this is created or used in situations where maybe people are traveling out of country for an extended period of time, and they want to give someone else legal authority to be able to pay their bills, handle their bank accounts, handle investments, those sort of things. They might create a power of attorney and then revoke it when they come back. There's also an enduring power of attorney, which is one that continues on past the point of you actually becoming incapacitated. And so the enduring power of attorney can either, again, start from a specific date. So for example, say someone is moving into a long-term care facility and they just find that it will be too difficult to continue to pay their own bills and they want to give power of attorney to someone. Then they would include in that document a statement around that it would be notwithstanding any mental incapacity or infirmary, and therefore that document would continue even past the point of them no longer having capacity. The other piece to an enduring power of attorney, it could also be sometimes what's referred to as springing, which is really just saying it's upon the decision that you no longer have the capacity to make your own decision. And so that's when that enduring power of attorney then becomes effective and continues on to be effective until the time of your passing away. So hopefully those are clear on those kind of pieces. We will go forward and we'll kind of talk a little bit more about each of these and how to create them and what they are, what's included in this decision-making area. There are some other personal decision-making options. If you don't create a personal directive, and maybe you don't require full guardianship, there are also supported decision-making options as well as emergency decision-making orders. And again, we can go into those as we move forward through this presentation. So we're going to just talk really quickly about green sleeves, which again are also called advanced care planning or sometimes goals of care. And this is really just a document that's a tool to have a conversation with your doctor and your healthcare team around what your goals of care are. So each person is responsible for their own green sleeve, and usually you can get those through your doctor's office. And you should be taking them back home with you after you've had the conversation with your doctor and you've been able to update them. Then you take it back home and you would bring it back periodically to update it if you have things that are changing for you medically, or maybe on, every couple of years, you want to bring it in and just make sure that things have stayed the same for you and you want to update it. We usually tell people to keep the green sleeve on their fridge or near their fridge in their home. And the reason for this is that our EMS folks have been taught that if a person has a green sleeve, that is likely where it will be. So they often, I would say probably about 90% of the time, will go and look for a green sleeve in this location. And so if you do have one, that's going to be the best place to keep it on. Green sleeves really look at the level of care that's going to be provided to you based on what your medical situation is. There are 3 designations under the green sleeve or the goals of care, and they fall into medical care, resuscitative care, or comfort care. And so the resuscitative care is really the most comprehensive. And this says that they will provide any kind of intervention and medical care required, including resuscitation, as well as followed by intensive care unit admission. So this could include as well intubation. It might also include the use of chest compressions or the paddles. All of those things would be options under this resuscitative care. And there are 2 levels under it when you actually are looking at the Greensleeve. And so you can actually choose from them. There's slight differences in what they'll provide or not provide. And so you can choose which one best fits for you. The focus really for this is to have care and intervention to be able to cure and control all of the patient's conditions. And usually this would be around, would be what would be provided for most people without any additional medical concerns. The next couple of levels are where we start to see maybe there's some maybe chronic illness or different diagnoses happen. And so you may want to adjust the level of care that you're being provided. So the next one is medical care. And medical care and interventions are any of these type of procedures. So that could include surgeries, it could include testing and x-rays and different scans, those sort of things. It might also include transfers to different healthcare settings. And also it would include medication and interventions in that way. Almost everything excluding resuscitation. So the focus for this one is around care and intervention for the cure and control of the patient's condition. And the patient can choose from either not receiving or would not be expected to benefit from attempted resuscitation followed by the life-sustaining care of an ICU. So it just takes out that piece so that if people aren't comfortable or don't want to be put onto life support or be resuscitated and brought back, this is the option that they can choose from a couple of different levels here in the medical care option to be able to say what they would prefer. And then finally comes to comfort care. And this is just exactly what it sounds like. So usually this is where we see a chronic or a some sort of diagnosis that has an end of life component to it, where people are just wanting to be kept comfortable. They don't necessarily want to have all the medical care and interventions to be able to keep them around much longer or to treat the illness or different things like that. The focus is really on keeping them comfortable and managing their symptoms. And so again, there's a couple of levels under this, and it can also be provided in the location that's best suited for the person. So it might be an ICU, it might be a hospice, or it may even be for another setting. So these ones are really important because if you are making decisions around not wanting to have all the full levels of care, then something needs to be noted around that you have this discussion, that you have the comprehension of what you're requesting, and that it's made note of in your medical file and that you keep the copy. So really what happens is with Greensleeves, once you kind of have the level of care that you want for designation, you'd have the discussion with your physician, and your doctor may have some conversation back and forth with you around making sure that you understand the full impact and decisions that you are noting. And then he makes a note in his own office around the conversation and keeping track of that and puts it into your medical file. And then you also update your Greensleeve form, and you would take that back home with you so that you would have that at home. Should EMS or some other medical service need to access it, it's easy to grab and you can take it with you. It's not actually a legal decision-making tool. So it's important to know that this doesn't have any legal decision-making authority. However, it is very helpful because if you are arriving into hospital and your decision maker maybe can't meet you there to make some of these decisions, it gives direction to your healthcare team once you arrive at hospitals to say, okay, this person has made these designations, and so we're going to try and follow their wishes. It also can really help your legal decision maker around medical decisions if you've outlined what you already want to have happen for you. It sometimes takes the pressure off or the onus that they might feel in making some of these very big decisions around your medical choices, and really says, okay, this is what you've already stated that you want, so they're just following your wishes, which is really what the decision maker should be doing in any case. So that's just a little bit about the Greensleeves. Again, if we have more questions at the end, we can circle back to this, but I just wanted to make you aware of it because not everybody is aware of goals of care, although I do think it's an important piece to talk about when we're talking about all of our advanced care planning. And they generally are available through your doctor's office, but again, you may have to ask for them, as not all doctor's offices readily carry them, because my understanding was that there was some provided to doctor's offices for free, and then subsequently after they had used those up, they had to pay for them, and therefore some of them don't carry them. But you can also order them, I believe, through Alberta Health Services. So then we'll get into enduring power of attorney and personal directives. So enduring power of attorney, which I'm going to probably refer to more often as power of attorney, I'm meaning the document that's pertaining to the financial matters. And in this presentation, we'll talk about it as being the enduring type, so lasting beyond your mental incapacity, and probably even that it is one that actually starts to occur when you actually are determined to be incapacitated. Personal directives is the document that we're going to talk about around the personal decisions. So when we look at personal directives, there are a number of different domains that are included. These are healthcare, accommodation, who you live with and associate with, participation in social activities, participation in educational activities, employment activities, legal matters, and any other personal matters. The things you cannot put into a personal directive are things around physician-assisted death. You also cannot put in there sometimes, you want to be careful about very specific things being put in there because it makes it sometimes very difficult for your decision maker to be able to carry those out. So we're going to talk a little bit about how you might write some things in there and how you actually create these documents. And I have some examples at the end of the presentation, but just to know that the personal directive actually has these domains available for you to be able to designate either all of the decision-making authority to one person, or you can break out these different domains to different people. And the reason that some people might do that would be if you have a lawyer in the family, for example, or a nurse in the family, you may want to designate that they are in charge of either your healthcare or your legal matters. And then perhaps you have another adult child that you would prefer to have decision-making over the rest of these areas. So that's one way, or sometimes people like to split it out so that they have different adult children taking care of different parts and in a more fair way. And then it provides a little bit of a checks and balance piece for your adult children to have to make decisions in these areas. So it's up to the maker how they would like to be able to do it. But we will go into some of the options available as well as some of the cautions that I would have for you as well. So generally speaking, these documents become activated in different ways. It depends on how you're writing the document. So both the document for personal directives as well as enduring power of attorney allow you to write in there who is going to determine that you have capacity or incapacity to make decisions. So usually the documents become effective when there is a question around your ability to make these decisions and your capacity around it. And it may even be triggered by certain events. So sometimes when there's a certain illness or an accident that may have occurred, or there may also just be some concerns that are happening that people are concerned about your welfare and your well-being and being able to continue making your own decisions. Sometimes people also can choose to activate these because they no longer want to be their own decision maker or feel like that's as easy for them to do. As we mentioned before, you know, if you're moving into a long-term care setting, it might be more difficult to be able to get out and make some of these decisions. So they may want to actually activate their documents at that time. When you're creating the documents, if you leave the sections blank around who decides whether or not you have capacity to make your own decisions, it actually falls back on the acts. And so for the Personal Directives Act, it says that 2 service providers, at least one of whom is a physician or a psychologist, will make the determinant about your capacity. And then the other one would be any service provider. So that could be anyone from home care workers to possibly a nurse or anyone else who is either willing and has the authority and ability under their profession and their role to be able to do that for you. And for a enduring power of attorney, that they fall back to the Act again, and that one is that at least one of them be a physician. And under that, it actually says that it must be 2 medical practitioners, not even just service providers. So it's a little bit more specific that they have to be medical practitioners. But again, that is open to interpretation. So generally speaking, we think of it as 2 medical physicians or a psychologist and a physician. But at times we have also had registered nurses or even midwives and things. Anyone who might fall under that Healthcare Professions Act would technically be somebody who could be considered as part of the legislation under the Act to be 2 of those medical practitioners. The other thing to note is that these documents have to become enacted when the person determines that you don't have capacity, and it has to be made in writing. So for the personal directive, there is a Schedule 2 or a Schedule 3. The Schedule 3 is filled out by a physician or a psychologist, and the Schedule 2 is filled out by the other service provider. And for the enduring power of attorney, it just has to be a written record. So there isn't a specific form to be filling out, but it does have to be in writing, and they must accompany the documents to actually make them activated. So this is a key thing to keep in mind as a service provider. You may be provided from time to time with these documents, but the way to know whether they've been enacted or not is that you need to have those documents that state that they no longer have capacity. Because until there is those documents attached to it, then this is just an inactive document that's been prepared and not actually a legal decision-making document for the person, the agent, or the attorney to take over decision-making. The other thing I wanted to mention is that in Alberta, a personal directive cannot be written and enacted on the same day. And the reason for that is that if you have capacity to make your decision around your personal matters and create these documents, which are considered legal documents, which is under that personal decision-making piece, you then can't turn around on the same day and say, oh, I no longer have capacity and can't make my own personal decisions. So that's just something to be aware of. You can do that with an enduring power of attorney. You can activate it the same day as it's created because it's you designating authority. So just that is a little note to be aware of when you are creating these documents or working with people to maybe help them. So in Alberta, you don't require to have the use of a lawyer to actually create these documents. But we do suggest that you consider this, as you might want to get some legal advice, especially if your situation is challenging or you have any complex pieces to it. In particular, some of the areas that we've seen documents challenged would be around if there's been a recent diagnosis, potentially one around dementia or Alzheimer's or something like that. Because you don't have to have somebody do a capacity assessment in order to create the documents. Once you've created the documents on your own, someone could question, well, I don't think that person even had the ability to make the decision at the time they created the documents. So by using a lawyer, there is a bit of a checks and balance, and they do run usually through a little bit of questions to ensure that you do have capacity at the time of creation to be making these documents. The other times that we've seen that it's very helpful to have a lawyer involved would be if there's blended families, with stepchildren or half siblings, or even just complex family dynamics where maybe adult children don't get along, or there's been an adult child or someone who's been ostracized from the family. These would be times where it would be a good idea to get a lawyer involved so that you're making sure that you are planning for the needs of all of your children and to be able to provide for those, but also managing the decision-making ability. Otherwise, you can also get the personal directives kit through the Office of the Public Guardian and Trustee. They don't have a form or template for creating a personal or an enduring power of attorney. However, there are some examples that you can look up online, and we will go through one of those at the end of this presentation, just so that you can see what that might look like. So when we talk about including things in your personal directive, again, we want to make sure that we're keeping information in there around our personal wishes and choices, and that we still keep it broad enough to give options to the person who you're appointing to the decision maker. So we've had people who have For example, I had one lady, she has adult sons, and she said, I don't think they're going to know about my level of hygiene and how I like to keep things. So she put in there that she would like to have her hair done every 2 weeks, and to make sure that she was having a bath once a week, or those sort of things. So there is some ability to write in your specific wishes. And one area that we most often see this would be around religious beliefs. So if you want to make sure that you are still attending religious ceremony, or having religious rights provided to you, or different things like that, you can actually specify that in your personal directive. Again, we would suggest that you keep it as broad as you can, with still giving enough understanding as to your wishes. But it also provides a little bit more direction, so that if that person isn't aware that that was something that was really important to you, or that you would want to have continue, it allows you to have that voice there. It's important that you're talking and making decisions around who your decision makers are going to be. So in the document, you have the option of appointing one decision maker, two decision makers who have to work together, a primary and an alternative, so that if the primary can't be reached to make the decision, or is perhaps away for some reason and can't be reached, that the alternative decision maker can then make the decisions on the behalf. There's different ways of being able to write that. So you want to make sure that you're being clear about your language in there. So if you're putting more than one person who needs to be the decision maker, and you want them to have to agree together on the decision, you want to put so-and-so and so-and-so. Whereas if you're putting, if you have just two decision makers and you're fine with either one of them making your decision, you can just say, for example, Mickey Mouse or Donald Duck can make my decisions for me. They don't have to necessarily make them together and agree. It can be either one. Or you can put primary Mickey Mouse, alternative Donald Duck. And then that allows those people who are receiving the document and reading it and interpreting it to know who is the legal decision. You also need to indicate which domains you are giving authority for them to make decisions about. For example, if we are creating these documents or updating these documents later in our life, we may not give anybody authority over our vocation and our education pieces, because that may no longer be applicable to you. So you don't need to necessarily designate or provide authority for those areas, but you would want to make sure that you have somebody in place for the other domains that are going to be important, like medical and legal and accommodation, those sort of things. Also important in there that you are aware and make sure that you put who will assess your capacity, or that you recognize that by leaving it blank, it's going to defer to the act and what it says in there. Again, anything around your shared beliefs and values. And more than anything, we suggest that you talk to the agent that you're going to be actually asking to be your decision maker. It's great that you put these things into your document. And while it's important perhaps that some of the information in there is provided so that people at the bank or people at your healthcare setting or in your living facility have an awareness of what your wishes were, more so, we really want to make sure that we get across what your wishes are and what your intent is and who you are and what's important to you to your decision maker, so that when they are making these choices, they can make them on your behalf and in your best interest and how you would be making these decisions. So this, when we put somebody in place as our personal directive and then our enduring power of attorney, they're there to make decisions like we would make decisions if we were still able and capable of making our own decisions. So they need to have that understanding, and that happens through conversation. So who can you appoint as your decision maker? It can really be anyone over the age of 18 who has capacity. And again, you may want to include more than one person, especially because we never know if somebody is going to have something happen. Perhaps, depending on how long you have the document enacted for, you could be living 20, 30 years. And in that time, perhaps something happens to one of them and one person passes away or moves far away and isn't as able to make decisions for you. It's a great idea to have more than one person. Again, it also provides a bit of a checkpoint and a bit of a safeguard that if more than one person would have to agree that, yeah, that would be the decision that you would have made had you had your ability, that can also help in some of the, be able to actually kind of make sure that you're not going to be experiencing abuse or having decisions made for you that you wouldn't want to have made. So once you complete the document, it's a good idea to keep them in a safe place. Sometimes people keep them on their fridge with their goals of care. Sometimes they keep them in a safe deposit box. But what's important is that you provide a copy of it to your agent and you make them aware of where they can actually find the original and where there might be copies. The other thing is, it's handy, like I said, about the keeping it on the fridge, because then it's easy to grab. And again, if your healthcare team or the EMS team comes in and they grab your goals of care and they're grabbing your personal directive, they know who already to be calling because they have that personal directive to say who is going to be your decision maker. So it's helpful in that way. The other thing is, in the kits that you can get from Office of the Public Guardian and Trustee, they actually have a card that you can put into your wallet. And this will notify anyone who looks in your wallet for contact information that you do have a personal directive, and it has who the contact is for more information and their number. There's also a personal directives registry available. We've heard mixed reviews on that as to how effective it is, so something to be aware of, but it is often a place where medical teams as well as housing providers will go to try and find out if there is a personal directive on file so that they know who the agent is that they can be connected. When you're creating these documents, you do require that there be a witness. And so there are some restrictions around who can not be your witness, which would be anyone who's under the age of 18, anybody who is incapacitated and doesn't have their own decision-making ability cannot be your witness. You also cannot have the person being named as the decision maker be the witness for the document. So it has to be an arm's length of that person. Additionally, you cannot have the spouse or the partner of the maker. So if you are the maker, you cannot have your spouse or partner be the witness. And you also cannot have the spouse or partner of the person who's being named as the decision maker. So apart from that, it can really be anybody. And it doesn't have to even be necessarily somebody that you're all that familiar with, which can be good at times and can also present some challenges. So we'll get into that a little bit more, but often it's a good idea to get somebody who either is maybe a neighbor or a neutral third party, but who knows you well enough to know that you do have capacity at this time to be making these decisions, and that you fully understand the decision and the document that you're signing and the implications that it carries. So then what happens if you don't have a personal directive or a power of attorney? It means that if something happens and you lose the ability to actually make that decision, as we mentioned before, a family member or a friend could apply to the court system to become your legal guardian and or your trustee. The only challenge with this is that the process can be very lengthy and it can be also very costly. So it's something to be aware of, but it is an option if those documents have not been created. And if you don't have someone to step forward, but there is a decision maker needed, then it will go through the court systems for a public guardian or a public trustee to be appointed. So for some of these things, I just wanted to let you know that, oh, I guess I'll go into that maybe the next page or the next slide here, but there is, as we mentioned, other decision-making options. So if they say, okay, you no longer have the ability to make all of your decisions, but maybe you just need some additional support in understanding and being able to communicate what your wishes are, there might be the option of a supportive decision-making order, sorry. And so this allows for people to have some support to be able to understand what decisions are being put forward to them, have maybe some communication around what their wishes are, and then that person can help even communicate what their decisions are around that. There's also a specific decision-making order, which allows for decisions to get made that are time sensitive, usually related to healthcare or a temporary admission to or a discharge from a residential facility. Or that might be also that you currently lack the capacity to make this decision, but it's not necessarily that it's a long-term thing, or that you are going to be putting a guardian or a trustee in place, but in the meantime, there's some specific decisions that need to get made, then a specific decision-making order can also happen at that point. Emergency decision-making orders often happen for adults who need emergency healthcare decisions made. And usually it's when it's around preserving an adult's life or preventing serious mental or physical harm, or maybe even to alleviate severe pain. And it's when the adult lacks capacity to be able to consent or be able to refuse the emergency healthcare procedures or things that are being suggested for that. So then they can go forward, and it's a process that the medical team and doctors would actually put into place an emergency decision-making order. So these are all, though, just for personal decision-making. When it comes to financial decision-making, there is no continuum of options or continuum of capacity. It's either you have it or you don't have it, and you have your ability to make your own decisions or you don't. And if you don't, it's either the enduring power of attorney, which you've created, or it goes to trusteeship. So when it comes to our finances, we don't have as much of a scale, whereas the personal decision-making side of things has a bit more gray and is a little bit more adaptive to the person's situation and their needs. So when we talk about guardianship and trusteeship, there's two different options for how you would go about applying for those. The first is a desk application kit, which is available through the Office of the Public Guardian and Trustee. They have it either on their website or available at their office. And the person completes those either themselves, or some people choose to hire a lawyer to complete them. Or you can also do an application kit, but it's for a court hearing. So rather than it just being a desk application, which is one where it gets submitted into the courts with all the documents required so that the judge can take a look through it and then give agreement or say, no, that doesn't fit. This one actually allows you to be able to go before the courts and actually state your information, but you still have to fill out the forms. And so there's a whole number of forms that you have to fill out. To be specific, there's, I believe, 6 forms to fill out for guardianship and 7 that you have to fill out if you're applying for trusteeship. Or if you're applying for a joint guardian and trusteeship one, then there's 10 forms in total. The cost for the court filing fees, I believe at the moment, is around $250. You'll also be charged for a criminal record check for each person who is being proposed as a decision maker on that. And then additionally, if you are needing to include a capacity assessment, which is usually needed for both the guardianship as well as the trusteeship application, a guardianship or trusteeship, if you're just going for one of them, a single capacity assessment on that end can run you up to $500. Or if you're doing a capacity assessment for both the guardian and trusteeship, it's up to $700. So as you can see, this very quickly adds up, especially if you're also getting a lawyer to help you fill out the forms. And if you are needing to also do a medical, you might have to pay for some medical procedures or things, because it does require a medical certificate to state that there isn't a medical reason as to why you would have incapacity that is going to change or be fluctuating in the near future, that sort of thing. So the least expensive of these applications is probably around $300, and the most expensive can run you up to a couple of $1,000s. So that is why we say it's much easier if you create your own documents and you have those ready to go, because you can even do those yourself, as we've mentioned here in Alberta, that's legal. Or even the amount that a lawyer would charge you to do those documents is going to be probably significantly less than a few $1,000s, and it's going to be able to be enacted very quickly, rather than this whole procedure of going through the court systems, which can take months. On average, I would say it's probably easily 6 to 8 months, at least before pre-pandemic. I would say that's what we were seeing in general. When we talk about capacity is something that has to be decided both for enacting enduring power of attorney and for personal directives, as well as for applying for guardianship and trusteeship. And capacity is really the ability to understand the information that's relevant in making decisions, and to appreciate the reasonably foreseeable consequences of making that decision or of choosing to not make a decision. So it is not about whether or not I'm in agreement that the decision that the person making is a good decision. We have the right to make bad decisions, but we have to be able to show that the person can appreciate that there would be consequences either out of not making a decision or even out of making a bad or a poor decision. And so things like having a diagnosis of Alzheimer's, having a person because they are drunk or an addict, having someone with a brain injury or a mental health concern, a disability, because a person's education level is very low, or because a person is just naturally aging, these are not reasons to declare someone incapacitated to make their own decisions. It is about functional ability to understand and make decisions, period. And the reason that I'm a little bit clear on some of these things is we get all sorts of calls around, well, I think this person should have guardianship and trusteeship put in place. And really, once, for example, say they're a person who is an alcoholic, once we get them into a position where they dry out and are maybe a little bit more clear-headed, they have the ability to understand and appreciate the decisions being put before them, and they can make decisions. Again, they may or may not be good decisions, but they can choose those. And they can explain to you what they think the reasonable consequences of those decisions are going to be. And they may still choose to go out afterwards and use alcohol and be drunk and be making poor life choices. That is still okay. They have capacity to do that. Do we wish we could protect people sometimes from their own selves? Sure, but that is not for us to do, and that is not the role of these legal decision-making tools. And so when we talk about doing capacity assessments, either by designated capacity assessors under that trustee and guardianship area, or even for doctors who are asked to do these capacity assessments to enact the power of attorney and the personal directives, they're looking at these cognitive functions. And so it's about ability to understand the information that's being presented to a person, the ability to appreciate the consequences, again, retaining information. So if anyone has ever sat in on a mini mental or a MOCA, there's often a list of words that they'll ask the person to repeat back later. It's around retaining information or be able to communicate information. Your ability to communicate information or lack of ability to communicate information does not impact your cognitive abilities. And so it's important that whoever is doing the capacity assessment makes every effort to be able to help the person to be able to communicate in a way that they are best able to, whether that be looking at hearing devices, being able to write out their answers rather than maybe speak that, having an interpreter, having a supportive person near them so that they can actually use them as a communication tool. These are all pieces that we want to make sure that we are looking at and being able to provide for, so that we don't let communication barriers impact our decision around cognitive functions. At the bottom, there's also a list of, in very small type, of other areas that we kind of look at. So things around executive functioning, understanding around having goals, how to set steps to achieve those, kind of sequential ability to set out how you would accomplish things. So for example, how would you go about getting groceries? You know, you might need to make a list, find transportation, purchase those, or get the items, purchase them, bring them to your house, put them away. Those sort of things of being able to sequentially understand how to do that would be some of those executive functions. Planning and knowing how to actually make a plan for the future and anticipating consequences. Reasoning around comparing different options available to you and how they might connect to other things. Flexibility. So are they able to have flexibility in their thinking? And this is one where oftentimes people will get people to draw different items from different viewpoints so that you can understand how their brain is able to be flexible in thinking. There's also around inhibition, whether or not they're able to ignore impulses or irrelevant information and be able to sift through to figure out what's actually important in the decision-making process. Time estimation, dual execution, so being able to multitask, do more than one thing at a time, and decision-making. So it's a bit more complex than just saying, oh yeah, I don't think that mom has the ability to kind of make these decisions anymore. And that's where I would say that when we're talking about who you're going to list in your document can make your decisions around your capacity, when you put in there that the person that you're going to list as your decision maker has the ability to make that decision, I would suggest that you want to be mindful of who you're putting as that and what their experience and their knowledge is on this, so that they can actually make a reasonable decision and reasonable kind of conclusion on your cognitive functions and how well or how poorly you're doing. The other thing is that all adults are presumed to have capacity unless determined otherwise. So it's presumed capacity, not presumed incapacity. And so when we go into these assessments, we want to be we want to ensure that we're giving all the opportunities for someone to show that they have their capacity, not that we're trying to set them up to have failure and prove that they're incapacitated. So we need to make sure that we're providing a time where we're doing some of these interviews, these assessments at times where the person will be at their best, where they have the ability to have supports around them or remove from the situation if they have another adult in their life who maybe is causes them stress or anxiety or pressures them. We want to make sure that then that person maybe isn't in the room when we're doing these assessments, so that that person can be at their best and not have to try and work in the, I guess, navigate that relationship and those dynamics at the time as well. There also needs to be a trigger. So what's happened that is causing a person to question what's going on, or that the person may not have capacity? It needs to be something that maybe puts the person at risk or puts other people at risk. And so we want to make sure that it's not just, well, we think this person is getting older, and so we're going to go ahead and do a capacity assessment on them and see if we can enact these documents, because they're kind of a difficult person and they don't really go along with what we want them to go along with. So we're going to go ahead and do a capacity assessment. That is not a trigger that's sufficient enough to actually move forward with capacity assessments. So again, just things to be aware of as we move forward and you're thinking about how you're going to write these documents, or if you're being asked to also be either a service provider who's doing an assessment or a medical practitioner who might be asked to do these. Just be considerate and really look at how comfortable you feel about doing these, how well equipped you feel to be able to do a full capacity assessment on the person, and fully understand the implications that your capacity assessment might have for them. I just wanted to quickly touch on complaints as well. For co-decision maker, guardianship, trusteeship, and if you have an enacted personal directive, you can make complaints through the Office of the Public Guardian and Trusteeship Office. The only one you cannot make a complaint for through that office is for an enduring power of attorney. So the process for that would be that you would write your complaint into the Office of the Public Guardian or Trustee, and they would then determine whether the complaint meets the criteria for an investigation, and that they would determine whether it's under their authority to be able to actually investigate the complaint. And then they would move forward with that investigation. And then there's a whole process of, they would let you know about the outcomes of that investigation and what happened, or what the outcomes would be for the decision maker. And so here's some of the criteria that they look for. It's all available through their website. So if you have more questions on that, I would suggest that you go there. The only opportunity that you have if you create an enduring power of attorney and the person is not fulfilling their role is to actually go forward through the courts to put in either a request for accounting of the funds that they've been expending and the decisions they've been making on behalf of the person who is the donor, or that you put in a complaint to have that attorney removed from the enduring power of attorney because they're not fulfilling their role. And again, that's the only option is through courts. And so I think it's very limiting, unfortunately, and it can be very uncomfortable for people and put them in a very difficult position, either from dynamics or even under their position of work or in their organization. They may not even be able to do that. So it can be very challenging. So some of the things that we would talk about preventing the misuse of documents would be things around, before making the personal directive and power of attorney, it's helpful, again, to talk to either a friend or a family member or a lawyer to maybe get a sense of what things you should be including, what others have put in there, what is unique to your situation that you need to make sure that you're including, thinking about your relationships with the people that you are considering to have that be your decision maker. And you need to make sure that you choose someone whom you trust. This is a key piece because it's going to be a person who is having decision-making ability when you no longer have that ability to oversee that or to change the decisions they're making. So you need to make sure that it's someone that you trust and that who knows you well enough to be able to carry out your wishes. Again, you may also wish to designate more than one person. The good thing about designating more than one person, as we've said, is that they have to agree. The challenge can be sometimes that if they are not readily in agreement on things, it can really make things slow down or even halt the process, and then decisions don't get made and it makes it very ineffective. So you want to make sure that if you're putting more than one person, that you ensure that they can actually get along, that they can come to agreement and be on the same page around decision making on most things. You might not get 100%, but on most items, you want to make sure that they would be getting along. And then again, talk to the person that you're going to be appointing to make your decision maker, just so that they understand what they're getting into and what your wishes are. So some of the things that have been pointed out as being challenging for these documents and can be pieces where we need a bit more safeguards around would be particularly in the enduring power of attorney, that there isn't another legislation option around putting forward complaints. So that would be a challenge, and I think it's something that you need to be really mindful of when we're creating these, that it's very difficult to remove somebody as an enduring power of attorney, and so we want to make sure that when we're creating it, that you're thoughtful and mindful of who they are, and that you're updating it as maybe things are changing for you, things might be changing in the other person's life, and again, just I guess being mindful of how you're doing it. So some of the good things are, I guess, that these documents have to be created and put in writing. So it's not just going off somebody's word that, yeah, grandpa gave me legal decision-making ability for him, so now I'm the decision maker. It's actually that the document has to be in writing, but it has to be witnessed, so that's good. And that it has to contain the clause that says that it's notwithstanding any mental infirmity or incapacity, and that it's enduring past the point of you being no longer able to make your decisions, which really would suggest that when you're creating these, you would hope that the maker then has the understanding that this is a document that is going to take effect when I can't oversee that anymore. So I need to make sure that I'm putting in people that I trust. However, because you can create these on your own, I think it does open up the door for coercion to be happening, or for other people to create the document and have the person agree to it and sign, even in the presence of a witness, to something that maybe they didn't actually want or agree with. So that is where I think enlisting a lawyer is a benefit, because it takes away some of those abilities perhaps for somebody to coerce another person into that. And so it's just something that we want to be mindful of when we're doing that, or when we're creating these documents. I just want to make sure that I'm not missing anything here. So some of the frequently asked questions that we often get in this area would be things around, can a person refuse to be my agent or attorney? Yes, they can. So when it comes time, they could not agree to be your agent or attorney or make your decisions. And then at that point, your documents become void. And unless you've named an alternative on there, you will have to someone will have to move forward to apply for guardian and trusteeship. So again, really important that you talk to them ahead of time so that they are actually in agreement and know that you're giving them that authority. What if my decision makers don't agree on a decision? So again, if they don't agree, this can really stall or even make decisions not happen. And so it becomes really ineffective. And in the end, what we've often seen happen is if there's multiple decisions that just can't be agreed on, it ends up going back to court, and the judge has to then make a decision on who's going to be the one legal decision maker, or goes towards a guardianship or trusteeship. Are agents or attorneys paid? Sometimes there is an ability for somebody to build in remuneration into their documents. So if that's something that's important to you, you can actually put that into your document. Some people do it based on number of hours that an agent or attorney is providing services. Some just do a flat monthly amount, yearly amount. And then others who don't actually put that into their documents have had an agent or attorney apply to the court sometimes for covering their costs, if there are any that they're paying out of pocket. So it just depends on what your situation is and how you actually want to be able to create that for your decision maker if you think that's important. Can agents or attorneys live outside Alberta? Yep, they sure can. There's nothing saying that they have to be here. The only thing that we would say is that they need to be easily reachable to be able to make these decisions. So there's nothing worse than having a document that's been enacted and the person not able to be reached for a decision on something that a person needs, because it just becomes really ineffective. And in the end, it just stalls things and makes it slower, and can also make it so that somebody has to go forward and say, no, we need this change to a guardian or a trustee because this just isn't working. So as long as your agent or attorney is reachable and is willing to make those decisions, then where they live doesn't actually matter. If you've just gotten separated or divorced, it doesn't void your personal directive or power of attorney. So you need to make sure that you're updating it. If you've had life changes like that, you need to make sure that you update these documents as well. If you have a spouse or partner who passes away, you want to make sure that you're updating these. If you have possibly children who are going through a separation or divorce, that might change how much they're going to be able to invest time-wise on or be able to make decisions for you. So you might want to consider it. Just different points at which you want to think about it and be updating these documents. And you want to do that quite regularly, or at least when things are changing for you, so that you're not left with a document that's outdated and not really what you want to have happen at this point. How long does a personal directive or a power of attorney last? They last until you pass away. So at the time of your death, these documents become void and it goes to the wills and estates, and your executor then becomes the legal decision maker over the estate. Are these documents effective outside of Alberta? They are, so much that you have them to be able to provide if there is something that happens and people need to know who your decision maker is and that they're able to follow that. So sometimes it's that a person isn't reachable, or that even under their legislation in their province or country, these might not be active or might not fit the bill, then they might not be as effective. However, where possible, I would say most provinces and even countries will try and use the documents you've created, because it provides them with a person who will step in and make those decisions for you, should you not be able to make those decisions. So I think that goes the same for these. Are these documents from other provinces valid here in Alberta? Again, yeah, as much as possible. If someone is coming from BC or Saskatchewan and they're bringing their documents with them, and something happens and they're no longer able to make the decisions, where we can, we try to use those documents so that we would be able to reach out to that person who's been appointed the decision maker to ask them to be making these decisions, so that we're not having to go through a court process here in Alberta and really stall the process of making decisions and getting things done for that person who's needing it. Is a personal directive broader than a living will? I have to be honest, I don't know. I'm not as familiar with living wills, and that is kind of an outdated term here in Alberta. The personal directive, what I like about it is that it does cover all the personal decision making, and it can be more specific. So it allows you to, again, use those different domains and choose who's your decision maker for each of those, or to even say, I don't need a decision maker in that area because it's no longer valid to me or important to me. And so I think for that reason, it's nice that we have some of those abilities, which I'm not sure that the living will would have. I think that was just a blanket, here's the decision maker, but I'm not as familiar, so I can't actually be sure on that one. And then, are photocopies of the documents valid? So the photocopies would be valid in some situations. If you're trying to show that there has been a document created, great. If you're trying to, depending on the situation, if it's just somebody who needs to kind of know, does this person have a document or has it been enacted, that could be. I would say that most often it's the original that you need to be able to present. And then the, whether it's the bank or the housing authority or the health care system that you're in, will likely take a copy of that original to keep on your file. So you providing a copy probably isn't going to be the most effective unless it's certified that it's a true copy. But there might be situations where that would be sufficient. And as we stated before, you do want to provide copies to your agent so that if they need to, they can show up and say, oh, there is a personal directive in place. And then they can have a chance to actually go and get the original and then have the enactment documents accompanying that. So it just, I guess, depends on the situation for that. But usually we want to make sure that we have the original that we're seeing and the accompanying documents that show that it's been enacted as well. Okay, so briefly, here is the examples that I have of filled out personal directive. So these are based on the forms that are provided through the Office of the Public Guardian and Trusteeship. And they're filled out in the way that we suggest to do it here, and that I've talked to, again, my lawyer friend who has suggested that these are good ways to be able to do it. So we always want to make sure that we put in our full legal name as in the name of the maker, because we want to make sure that it's not going to be Mickey Joan Mouse, it's Mickey Ann Mouse. So we want to make sure that we put in the full name there. We also want to make sure that we're revoking any previously written documents. And when you're revoking, if you've had a previously written document, you want to make sure that you also update and let know any previous makers or agents that you had listed on there, as well as any other places you might have provided a copy to of this personal directive. Be able to say, oh, this is my updated document, so that they now have the most current one. The designation of the agent. So this is where you get to choose who you're putting in. You can see here there's a primary and a secondary. So that means Donald will be the main decision maker, but if there is some reason why Donald can't make the decision or isn't reachable, then Sylvester Cat can also make a decision on my behalf. And then putting a line for the other options, because these are, you can either choose that, or you can choose a public guardian if you don't have somebody to name, or you can just put that you don't have a designated agent. If you're choosing that first option, make sure that you put a line through so that it doesn't look like you've just missed that or that you've skipped over it. And then the lawyer suggested initialing after each section, again, to show that it was you who went through it and who have agreed and made the designation in that area, and that you haven't just skipped over it for some reason. So that the initials kind of at the corner isn't necessarily needed for this, but it just allows you to kind of have a little bit more showing that you've been through it kind of more in depth. Same with the areas of authority. So you can, again, here give authority to the person to make all the decision-making matters in the personal area, or you can break those out as the domains below and name each agent separately for each area that you're listing them. If you're choosing to go the first route, again, putting strikes through just shows that you've not skipped over that area in error. There we go. Second page allows you to be able to put in there if you have any minor children, who is going to be temporarily caring for them until a court process can go forward and actually place them permanently. If you don't have any children or dependent children, you can just put a cross through that. Specific instructions allows you, again, to be able to give those specific decision-making things. This is sometimes where people will give some medical decision-making information as to what they would want. You could do that. You can also keep it in that goals of care document so that it's also documented in your medical file. You can also put in here some of your personal decision-making things, as I mentioned, around the hygiene or about your religious pieces. And then other information also allows you to do some of that. So these might be discussions that you've had, and you might want to put in there around how many times a week you want your hair and nails done, or I don't know, things that might be important to you that didn't fall into those other areas. Area number 7 is really important. So this is who is determining your capacity. So again, you can put in there 2 doctors, 1 doctor and my agent, 1 doctor and a service provider, or if you leave it blank and just initial it, it defers to the act. And then also notification. So the notification is more so for who you want to be notified in the event that you are no longer able to make your own decisions. So for some people, it's other children who live far away, who aren't the agent that they've listed, but they want them to know, okay, mom's no longer able to make those decisions. So if I have a question about that, I now have to go to the agent. Lots of people just leave it blank. So if you want to leave it blank, you can just put crosses through it. And then section 9 is where you would actually do your signatures and your witness, and then your witness would sign as well. And then the back just allows you to put on there who you are giving copies of the personal directive to, if you have done that or want to do that. And oftentimes just left blank. We have made some suggestions around things you might want to put into those different areas kind of that were in there around filling out additional information. So again, some of these are around resuscitation and being put on life support. I don't really like this as much. It's an option available to you. I think that the goals of care is much more specific and allows you to have a better, because each area has different levels, I think it's just a little bit more comprehensive than you writing something in. So that's just my personal opinion. And then this might be an example of what an enduring power of attorney might look like. Again, there is no template that's been created, so it's up to each person to write their own, but this is one that we have seen, and that is pretty similar to the personal directive, which is quite nice because then the two documents look similar and are easy to kind of go through. So again, naming the maker, revoking any previous, you only have the option of designating the attorney or not, and there isn't really any additional options for areas of authority. It's either they have the authority or they don't. So that's where number 3, you either choose or you don't. And then you can, again, in number 4, determine who is able to determine whether or not you have capacity. If you leave it blank, then it just defers to the act. And then on the right-hand side is one kind of just as an option filled out. And then they've also offered an option here of payment. So if it was something that you wanted to provide payment or remuneration for the attorney that you have, this would be an opportunity to put that in there. And then again, section for notification if you want someone to be notified when you're no longer able to make your decisions. And then the same type of signature and witness as the personal directive. So that is it for my presentation. I recognize that we went over a lot of information in a very quick time, and I noticed that we do have some time available for questions. So I'm going to stop sharing, and I'm going to ask the other committee members if they wouldn't mind to help facilitate the questions. So I don't know if we already had some questions in the chat box or if people just want to raise their hand and we can go through some.
I see one from Tatiana, JFS Edmonton. What if the person doesn't want to go through a capacity assessment?
So you have the right to refuse a capacity assessment. And so to me, that would be, so there's a couple of options. One, you can actually take this forward to the courts to actually request that they go through the capacity assessment or mandated, whatever required to, or depending on the situation, if it warrants, it might be something that can be applied for under the Mental Health Act. The other thing to me is if somebody is refusing, it kind of does show that there is at least some level of capacity to understand that if I accept and go forward with a capacity assessment, that the implications of that may mean that I no longer have the ability to make my own decisions. So that always kind of is a bit of a red flag to me that they might actually have capacity, or at least are along the continuum somewhere. And I would probably want to have a bit more of a discussion about them around why you do or don't want to have a capacity assessment. What are your concerns? What do you think the reasons, what will happen if you have one and you're found to lack capacity? Or I think I would just want to find out more if they're open to that discussion. If not, it might be something, and if it's a real concern and there are some really big triggers happening, that you might want to look for going towards courts to actually ask them to require that. And you can apply for guardianship and trusteeship. I believe without a capacity assessment, you just have to put in there that the person refused, but that these are the reasons why you're requesting that they still have a guardian and trusteeship. And that's usually where court will then require it, the person actually undertake that, or that one might not be required to actually put in place the guardian and trusteeship. I hope that's helpful. Okay, good. Any other questions? Oh, I think I see a hand here. I can't see the first name, sorry. Not Hughes, it was the last one.
Yeah, it's Lana. Hi, Shantel.
Lana. Go ahead, what's your question?
When a person regains capacity, can a lawyer reverse the capacity by drawing up a new document?
So it depends what document has been enacted. There is a regained capacity process, and that is listed on the Office of the Public Guardian and Trusteeship. My understanding is that it's most often used in trusteeship and guardianship, and it is much more difficult to reverse an enduring power of attorney if that's a document, because it requires going back through the courts. However, there is that ability, and so it requires a capacity assessment and agreement from, I believe, it's a physician and a capacity assessor, that they are both in agreement. And then there's certain forms that are filled out and provided to the courts, either to reverse that enduring power of attorney or to reverse the guardianship and trusteeship, because it's considered a regained capacity. So the process is listed on the Office of the Public Guardian and Trusteeship website if you want to take a look at those documents. I have been a part of one, and I will say that sometimes from time to time, even in these situations, someone might have a stroke and there might not be, for example, maybe they've had a time frame 6 months to a year where there's not a lot of improvement and they really just aren't able to make some decisions on their own. But then down the road, 2-3 years, there's significant improvement. That's a time where we want to go back and revisit that and look at whether there has been regained capacity, because we don't want to keep in place any of those decision-making tools if we don't need them, because we want to make sure that the person has the most autonomy and the least intrusive measures where possible. So it might also be a regained capacity, and maybe then it's just supportive decision-making that's helping that person out or something. So for more information on the actual process, I would suggest going to the Office of the Public Guardian and Trusteeship website. Any other questions? Ooh, okay. That's maybe good, I'm not sure. Lana, did you have another question? Yeah.
I did, yes. And it's just about commissioning of oaths for legal documents. Is that necessary?
Not usually for these documents. It just, again, it can be a witness. And oh gosh, I'm trying to think of. Nope, and it's not required as well for any of the capacity assessments, to my knowledge. I haven't looked at the Schedule 2 in a while, but it's not, you have to, for the guardianship and the trusteeship, if you're a designated capacity assessor, you have to put your ministerial, so it doesn't require that. Some of the documents under the guardian and trusteeship application may require it. It's been a little bit since I looked at that. But if you need a list of those, usually Office of the Public Guardian and Trustee would have a list of who you could get to commission those as well. Or any lawyer's office usually has a commissioner.
Yeah, and there are some commissioners in Medicine Hat as well.
There are, yep, you bet. There's a handful of them actually. And I think even the process of becoming a commissioner for oaths isn't all that difficult. So if it's something that you're seeing a lot of forms coming through your office, I know a lot of our senior centers across the province have somebody in their senior center who actually can do that. So it might be something worth considering as well if you're finding that a need for people.
Okay. I have one more question if there's nobody else that's asking.
Sure, go ahead.
What is the difference between a co-decision maker form and a supportive decision-making form?
Great question. So a supportive decision-making form is more of a person's there to be able to assist you. They aren't actually a legal decision maker on your behalf. They're just there to help communicate and to help you understand the information. A co-decision making order actually means that a person is appointed into a legal decision making role to assist another person in making those decisions. And they kind of have to work together in agreement that these decisions are being made. So it's an order through the courts that gets put in place. Supportive decision making is usually just one where both parties agree into it, and they might even sign off on the supportive decision making form, but it usually doesn't go through the court process, and it usually doesn't grant the person legal decision making authority or co-decision making authority.
Could you give me an example, Shantel, of when to use the co-decision making form?
You bet. So we have had sometimes where people with a disability maybe need a person to kind of agree with, for example, maybe somebody with less severe, I don't know what the best word, high functioning Down syndrome might need some assistance to be able to understand and decide, where they're going to live and what vocational training they're going to take and what job. They might just need that extra support in making those decisions. And we want to make sure that they have somebody there who is agreeing and making sure that they're not going to be taken advantage of, or maybe make a decision without fully understanding it. So that type of co-decision making can really help them. But as a person with Down syndrome, they might be very able to make day-to-day life decisions and not need support all the time. So having that co-decision making person there for some of those larger decisions is often very helpful. And so it just gives, again, authority to the other person that they can be present, they can help make these decisions. Especially in the realm of legal and medical. I would say those are quite big areas where we want to, if you have somebody who's got the legal decision-making authority, it helps to be able to release information and provide that sort of communication.
Thank you.
I have a question here from Sherry Mullen. Unfortunately, some people have few or no people in their lives. What can they do if they have no one to name? Do they just fall under the OPGT?
So you still can create the document, as you saw with the personal directive. There is an option of putting in there that you're not naming an agent, but that you're still listing your wishes in there and making decisions as to who determines your capacity and some of those things. But yeah, when it comes down to it, if there is nobody to apply for it or who is going to step in as your decision maker, it does fall then to the Office of the Public Guardian and potentially the Office of the Public Trustee, although that's a little trickier sometimes because there are some fund requirements as far as assets, and if you don't have the assets or meet their criteria, you might have to have an advocate kind of step in for you. So sometimes it gets a bit tricky, and it really does put a little bit more work involved for our healthcare system and social workers and healthcare teams who are working both in a hospital setting as well as some of our care facilities and housing facilities, because they may have to work through a longer process to actually get something in place for that person so that they have a decision maker. But unfortunately, those are kind of the only options if they just don't have anybody in their lives. Any other questions? I hope this was helpful for you. Just I wanted to mention that I know we tie this back to elder abuse. And the key thing about this is that we really want to empower people to make good decisions and to be empowered with knowledge and understanding of these documents so that they can make some good choices around who they're putting in place for this, and that they're really able to think about different situations that might impact the person's ability to make decisions on their behalf, and that they, in particular with that enduring power of attorney, it can be very difficult because once somebody has access to all of your money and funds and opportunity to do things with, sometimes things change for people, and unfortunately they might take advantage of those situations. So doing what you can to put in place maybe more than one decision maker and having additional witnesses or people aware of what your decision making wishes are, and trying to use all of those kind of checkpoints as ways to try and deter anything from going sideways and being bad, or being used as a tool to, a form of to be able to abuse somebody, I think is important. So that's why it's so important that we do education and we do work with people and help them to understand how to best create some of these documents so that we try and mitigate some of those concerns later. And even there's some interesting stuff out there. If you look some more about it, power of attorney and things, I did even find a list of like what qualities should the power of attorney have that Turning Point Law has kind of put out and stuff. So there's lots of information to try and help you out there. If you have more questions, you can always connect back with me as well. And if I don't have the answers or information, we have great colleagues over in Office of the Public Guardian and Trustee, as well as in the designated capacity assessment area and things. So if you have questions about anything further that we didn't touch on or that you didn't get enough information on, please let me know and I'm happy to try and follow up as well. I think I see one hand up. Laxman, did you have a question?
Hi, yes, I do have a last minute question. Yeah, I have a client, she's a senior, very senior, like in her 80s, and her spouse is already in long-term care due to dementia. They haven't made any papers. Now she has a big old house that is always going on something and lots of utility. She wants to sell that house and have a small apartment for her, but there is a name of both of them on the property, and she's struggling a lot. What do you suggest? How can we support that senior who is struggling to pay those huge utility bill in that old house and to maintain lots of ongoing issues?
So probably I would suggest if there's not any documents in place and the person has already been declared to be incompetent, so he's no longer able to make his own decision. Okay, so probably I would suggest that you need to suggest that she goes forward and either gets a trustee and guardianship in place if they haven't created the documents, or enacts documents that they have, so that under that trusteeship you can actually request permission to be able to sell assets. And so she could then have the ability as his decision maker, as well as herself, and being the joint names on the asset, to be able to sell that house and then downsize. Or if somebody else is going to be his decision maker, it would just need to be that that person agrees with her and that they both go forward and actually sell the house, so that they can do it. The other thing is she could apply to the courts for just a special permission to be able to sell the joint asset, because they might need the funds to be able to provide his care, or for her to be able to continue living. And oftentimes the courts will be receptive to that as well, and understanding, and give permission. But it sounds like either way, it's probably going to be a court process, unfortunately. Okay. But yeah, no, I would suggest that that probably is the best way forward, and is going to at least allow her to be able to move forward and get, sell that asset so that she can use the funds in other ways. Yeah. I hope that's helpful.
Okay, yeah. Thank you so much.
You're welcome.
I have a question from Tatiana. Is there some work done around getting nonprofits to become guardians, as it is in some other places in Canada and the States?
So we have not, to my knowledge, had many looking at that, just for the fact that it becomes very complex if you have rotating staff and the liability around it, and all of those kind of pieces. So I'm not aware of any nonprofits that have been willing to do that. I have heard of service providers who have been maybe long-term connected to an older adult, who have been willing to step in as their decision maker on a personal level, like, I'm connected to this person, so I agree to be their decision maker, because they just don't have anybody. But I haven't heard of an organization necessarily going forward with that. So if anyone does have any information or knowledge of that, I'd be interested in hearing about it, because it is a gap. And I do think that the Office of the Public Guardian and Trustee is very busy, and they have a lot of cases. So if we have more seniors coming up that don't have family members or people in their lives, that might be a good alternative. I just don't know that anyone has moved forward with that due to liability and some of these other concerns. So thank you for that question, though. And I think that might be the last kind of time that we had for that, as I see we're at 2:30. So I'm just going to let Cindy take it over and maybe mention just a minute about CORE, and then that will be it for our session today. So thank you, everyone, for the opportunity to be able to speak to you.
Yeah, thank you so much, Shantel. I just left in the chat box a link for you all to become a member and join us on the CORE Elder Abuse group. We will also send out an email with a short survey. It's also left in the chat box. If you can just take a few minutes to fill it out, we would really appreciate your insight on the event today and how we can plan future events for you all. And yeah, thank you so much for joining us today. Wishing you a lovely day.
Thanks, everyone. And thank you for sharing the resources in the chat box. That's very helpful. Have a good day.